Twitter, Facebook, and Instagram. You can also stay connected with the Glendale City Connection. The email newsletter is sent out at the beginning of every month, covering events, news, and projects in your neighborhood. Visit the city's homepage to sign up. That's it for this week's edition of Glendale's Look Ahead. Thanks for joining us, and we'll see you next time.
Good evening and welcome to the City of Glendale Civil Service Commission. Today is June 25, 2014. May we please have roll call?
Commissioner Yakubian?
Here.
Commissioner Devine?
Here.
Commissioner Hatamian?
Here.
Commissioner Manukian?
Here.
And Chair Gazarian.
Here. Thank you. Next item, please.
Reorganization of the Commission.
Thank you. Mr. Doyle.
Mr. Chair, members of the Commission, this is the meeting occurs annually where the Commission is reorganized in the selection of a Vice Chair and a Chair. So I think at this point, if the Commission or any Commissioners want to make a nomination for either of those two posts, in no particular order. So
that was not on the agenda.
It was not on the one that was sent.
Item number 2.
Was it? I totally missed it. Oh, I'm sorry. Looking at the wrong agenda.
That's right there.
Sorry.
Commissioners.
As I said, I didn't even know it was on the... Can we do this next week? I mean, the next meeting?
Mr. Doyle.
If there's agreement on the commission to push the item, then you may.
I would recommend we do it at the next meeting. But then again...
But the item does not require any report or any additional information on the part of staff. So if the commission wanted to consider it at this time, you may do so as well.
As I said, that's my recommendation.
Yeah, I would second with Sam.
Any discussion? Okay.
We will defer this item till our next
By
meeting.
consent. Very well. Thank you. Next item, please.
Minutes.
Move to approve and dispense from reading.
Second. Yeah.
Unanimous consent. Thank you. Next item, please.
Oral communications.
I see no cards and no one approaching the podium. Thank you. Next item, please.
Recruitment and examination report.
Mr. Doyle.
Mr. Chair, members of the Commission, we bring this report to you each meeting just to give you sort of an update on our recruitment activity. The report does show our recruitment activity as far as opening, closing dates, the dates of any particular exams, and the processes thereof. This really is a note and file item. If you have questions on any of the recruitments and the staff that they're assigned to, be happy to try and answer them. Otherwise, it is note and file.
Seeing no questions. Any questions? Hearing none. Thank you. Next item, please.
Eligible list established.
Thank you. Mr. Doyle.
Mr. Chair, members of the Commission, this item also is note and file. It's the eligible lists that have been established since our last meeting. As I often say, it's the culmination of our very structured hiring process is the establishment of an eligibility list. The report shows looks like 11 lists have been established, mostly promotional, but a couple open recruitments. And again, you kind of see the last two columns, the number of applications received, and then the far right column has the number that actually make the eligibility list. And you'll see there was a couple of recruitments that did attract quite a number of candidates, which is somewhat a sign of the times. We have over 1,000 for this community service officer position in the police department. And a couple of the other ones were one with 127 and 195. But for the others, the promotional ones, obviously the pool is limited to our internal candidates, so it's a much smaller group that we're dealing with. But again, each of these processes has filing periods, various examination components, and ultimately those who are able to make it through that process get onto the list and they're considered for hire. So if there's any questions about any of these eligible lists, any of these positions or the processes that went into them, again, I'd be happy to try and answer them. Otherwise, it's a note and file item. Move on.
Any questions? Hearing none. Next item, please.
Class specification for approval. Director of Communications and Community Relations.
Thank you. Mr. Doyle?
Okay. Mr. Chair, members of the Commission, the next few items on the agenda relate to class specifications, primarily for new classifications that have been established and were part of the budgetary process as adopted on June 3rd by the City Council. The first is the establishment of an executive level classification called Director of Communications and Community Relations. The individual in this position would oversee really a subsection of the Management Services Department consisting of the Public Information Office function, also all of the respective departmental PIO individuals, the GTP6 function, the graphics function, as well as the Community Relations group. Again, upon approval by the Commission, the City Manager does hope to make an appointment to this position relatively soon after the start of the new fiscal year. The specification is here for your consideration, and we have Mr. Ochoa here and other members of the Management Services staff to answer any questions you may have.
Any questions? Go ahead.
Couple of questions. First of all, what is the pay range on this position?
I defer to Mr. Doyle on the range.
Mr. Chair, members of the Commission, if I could memorize all of the pay ranges of all of our jobs, I'd be a genius. But it is comparable to a number of our other department head positions, including the Chief Information Officer and I believe Director of Libraries and
That's right. The range would be from $98 a month to $13.8 a month, which would be consistent with the internal auditor, I believe, the Director of Community Services and Parks, the Deputy City Manager, and the
Library Director and Chief Information Officer.
Okay. Will this be a open or promotional exam?
I'm looking to make an appointment, sir.
How does that work, Mr. Doyle, when there's a new classification and apparently there's no exam then? They just make an appointment from whomever they want? Or
there's a provision within both the charter and the rules that allow for the direct appointment of a department head position of recognized attainment and a position that's created by ordinance. And this position, this classification, was created by ordinance at that June 3rd City Council meeting. So, like several of the other executive level positions, this the City Manager does hope to make a direct appointment.
Okay, that's all I have.
Any other questions?
I have a question for Mr. Ochoa.
Yes, sir.
Who's currently performing this function, informing the media and so on?
The staff person would be Sergeant Tom Lorenz.
Tom Lawrence.
And we have a number of staff scattered throughout the organization that do public information functions, where the maturity or the growth of this particular position and the responsibility and need for the elevation of this position is the centralization of all of those responsibilities from across all of our different departments, to have the city speaking with one voice effectively and have that come out under the Management Services Department of the Manager's Office. So currently Tom does it, but he coordinates still all of the other action throughout the rest of the organization.
Got it. And since this is a newly established position, have the needs for the city changed, increased for there to be this type of a position given the salary specs?
Most certainly, sir. Thank you for asking that. To the extent that the position continues to have GTV6 and continues to have the marketing and graphics function, the advent of social media and the leading edge profile that Glendale has in that realm, and you saw it beautifully displayed in the Hillside Fire just this past weekend, dictates that we need to have somebody at the central point of contact for the media, for the community, and to really be strategic in the manner in which we put information out, because that information is going out instantaneously. People demand it so quickly. That means that somebody at the appropriate strata of the organization needs to be able to interact with other execs. So that in and of itself is one of the major needs, impetus behind this position. And really the that and the centralization being the main difference between positions that have existed in the past in the PIO and this position here.
Got it. Thank you.
Yes.
Just a quick comment for Sergeant Lorenz. I mean, I have to tell you, he does a phenomenal job. I have not seen anyone handle that position like the way Sergeant Lorenz does. And it's a very tough position, I could just imagine, because there's certain things that you have to release, there's certain things that you can't release, and there's everything in between. And I have to congratulate Sergeant Lorenz for the work that he does.
Yes, sir.
Just phenomenal.
Commissioner Manukian is going to outlive me, but I would be remiss if I did not make the following statement. Those of us who live in the city, we know that Sergeant Tom Lorenz has been the voice of the city for quite some time, and he has been an eloquent voice as far as this commissioner is concerned. I'm personally familiar with his efforts during the fire over the weekend, though he was out of town. So it is my hope, though all my hopes are not always realized, that it is my hope that that appointment from within would be, in fact, Sergeant Tom Lorenz. That's all I have to say, and I'd ask for a motion to approve the specification.
I move to approve.
Thank you.
Thank you, Commissioner.
Second? Any second?
Second.
All those in favor, yes?
Yes.
Okay, very well. Thank you. Next item, please.
Class specification for approval, Departmental Human Resources Officer.
Thank you, Mr. Doyle.
Mr. Chair, members of the Commission, similar to the previous item, this would be adoption of a new classification within the HR department, Departmental Human Resources Officer. This is an advanced journey level position reporting through the Human Resources Department organizational structure, yet assigned to one or more city departments. The HR department in the city of Glendale is somewhat uniquely organized. We utilize what's known as a generalist approach with our staffing, whereas some cities they'll look at the HR analyst series and they'll assign an individual to do nothing but recruitment or employee relations or labor relations or training or benefits or class and comp. My approach is to give the staff exposure to all of those various areas, and instead, wait for them to attain a certain level of expertise and proficiency in those areas, and then assign them to one or more departments where they serve as more or less the in-house expert in those areas, and literally be a resource for those departments on all matters HR related. And it's a system that's been in place since I've been in charge, and I think it's worked well from both a customer service standpoint and serving the needs of our various departments and the staff that we have. Again, it's not something that you can take an entry-level employee and put them into a role like that. It generally takes several years to attain that level of proficiency. We still do have a Human Resources Analyst series, which has an Analyst 1, 2, and a Senior, but this would be in between the Analyst 2 and the Senior, still in a mid-management classification, but at a level to where I'm comfortable placing individual or individuals within each department to really be their resource person and literally be available 24/7 to whatever those departments need. And like I said, it's worked well, but the existing HR analyst series we have doesn't quite address the component of this that I'm looking for. So with that, I'd be happy to answer any questions you may have. Again, this concept, this classification was approved by City Council, and I offer you this specification for your consideration.
Any questions? Yes.
Basically, the same question on this one, Mr. Doyle. First of all, will this be an appointment or is it an exam process?
This would be an exam process.
Be open or promotional?
It would be promotional.
Okay. Do you know offhand about how many candidates would qualify at this time from your organization?
3.
Okay. That's all I had.
Okay. Any other questions?
Move to approve.
Second.
Unanimous consent. Thank you. Next item, please.
Class specification for approval, housing systems analyst.
Thank you. Mr. Doyle?
Mr. Chair, members of the Commission, again, similar to the previous two items, and again, if it seems like there are a lot of new classifications being introduced tonight, it's a function of the budget. Each year we look at our needs and the organizational issues, and so this is yet another one. This is a position within our Community Development and Housing Department, specifically the housing section. This is actually an IT-related position within the housing section, and this is the individual who oversees the software systems that are essential to running the Section 8 programs throughout the city. It's very specialized. Most of the knowledge, skills, and abilities addressed in the specification relate to IT knowledge, but the individual does need to have a good working knowledge of housing and Section 8 in particular in order to be most effective this position. Right now we would anticipate reallocating what is currently a systems analyst position, a very generic position, to a more specialized classification of housing systems analyst within this particular department. If you have, again, questions, I'd be happy to try and answer them. And we do have representatives from that department here to answer questions as well. So,
thank you. Any questions? Hearing none, any motions to approve?
Move to approve.
Second.
Unanimous consent. Thank you. Next item, please.
Class specification for approval, Public Works Manager Series.
Thank you. Mr. Doyle?
Mr. Chair, members of the Commission, I promise you this is the last one this evening. Once again, a new classification. This is actually a series of two classifications. Again, as we prepare for the new fiscal year, there are going to be some significant changes within the administration or administrative structure of Public Works. And some of you, I know you're aware that Mr. Galanian was recently appointed as our Director of Public Works.
I think that's, we are very blessed, and it's the city that gains, and congratulations, Mr. Galanian.
And also probably some applause goes to Mr. Zern as well, who held the Director of Public Works position as well as the Water and Power position. Did that for 2 years. That was quite a workload for him. But Mr. Zern is moving to Water and Power full time, and with him he is taking some key administrative staff to Water and Power. Therefore,
so he's stealing from Mr. Galanian. Is that?
Didn't say that, but. Therefore, Mr. Galanian is going to need some assistance in the Public Works Administrative Office, and what we do need is a couple of classifications to serve as his immediate assistants who really know the Public Works field inside and out, and that's the point of this series. It's called Public Works Manager Series. We have a Public Works Manager and Senior Public Works Manager. I think the intent would be to, once the transitions occur, to have some positions reallocated through promotional examinations to serve Mr. Galanian in his new capacity. Mr. Zern and Mr. Galanian are here this evening, so if you have questions of either of them, or myself, I'd be happy to try and answer those questions. So.
Any questions?
I'm just curious on the org chart where it shows the Senior Public Works Manager. I'm not sure where that person fits in. You show two Public Works Managers, but the senior position seems to be not there.
Correct.
Mr. Chair, Member Devine, the way we set these up, because this is really, let me first go on the record as saying I'm not leaving the cupboards bare as I cross the plaza, believe me. But I think this is more of a function of a very streamlined department. When I became the Director of Public Works, I had 7 divisions and 7 division managers. Rubik will get 4. and he's an example of someone who took 2 divisions on. And we have another manager who did that as well. So there's a lot of help throughout the organization. So the idea is that these positions are assigned under administration and then at the director's discretion assigned out where needed in the department. So they're functionally in administration, but for the rest of this month they may be in fleet, or for the next year they may be in maintenance services, wherever that need is.
Okay. That answers that. Thank you very much.
So you are stealing from them. I'm just kidding. I'm just kidding. Congratulations, by the way, both of you. Thank you. Move to approve?
Second?
Second.
Thank you. Unanimous consent. Next item, please.
Discussion regarding the civil service rules and regulations to a civil service employee's right to seek review by the Civil Service Commission of a performance-based transfer.
Thank you, Mr. Doyle.
Thank you, Mr. Chair. Members of the Commission, I'll do a brief introduction and then turn this over to representatives from our City Attorney's Office. This item was originally placed on the agenda for a special meeting on April 21st, 2014, but was continued to today's meetings. This item has to do with discussion of whether performance-based transfers for sworn police officers should be reviewed by the Civil Service Commission. Under the Peace Officer Procedural Bill of Rights, often known as the Peace Officer Bill of Rights, or POBAR, the Government Code provides for an administrative appeal when there is an action such as a transfer which would result in the loss of pay. Our recent history on this subject is a bit mixed. For the longest period of time in our history, there was no process in place to address these types of appeals, and again, the history looking back, and Ms. Farpetian, I think, did a very nice job of sort of summarizing where we've come from. Back in 2008, this item was brought before the commission, a much different commission at that time, and discussion was ensued about bringing these types of transfers to the Civil Service Commission. In 2011, for reasons that no one really can recall, a separate alternative administrative appeal process was developed with the assistance of outside counsel, which would have these matters adjudicated administratively, where the appeal would be addressed by the police chief or the assistant city manager, much like the predetermination phase for a Skelly process, so to speak. That policy was put into place temporarily, then brought forth during labor negotiations with the GPOA in 2011. Again, this policy has been in place and has been offered to at least 3 or perhaps 4 officers, and over the course of its existence. Although one officer, only one availed himself of that particular process. Again, given the concerns that were raised a few months ago by an outside counsel for one of our police officers, we've had the need to bring this matter forward and for discussion. And again, you're aware that Ms. Farpetian did some research on this, and both what occurred in 2008 and 2011, and we're opening this item for discussion this evening for the Commission's consideration. We do have, again, Ms. Farpetian is here, Ms. Maurer from our City Attorney's Office is here, as well as Ms. Marino, who's General Counsel to the Police Department, and Chief Rob Castro. So with that.
I have a few questions. Of course, I will allow my fellow commissioners to ask any questions they have, but I don't know who is best equipped to answer the question, so I'll pose it to you, Mr. Doyle. The first question, okay. What is the status today as to any officer who is subjected to a performance-based transfer? Does that officer, he or she, have the right to come before this commission as provided for in Rule 10, subsection A and subsection B of the Civil Service Commission rules?
And again, the current practice, Chair Gazarian, would be the utilization of the administrative appeal procedure.
So the answer is no.
That's correct.
Okay.
That's
then having
right or wrong. And
right.
I
No, I understand.
acknowledge
I understand.
the ball was.
But I want to
definitely
identify
dropped.
the issues before this body. So if that is the case, in 2008, when, as you said, a very different commission believed that an officer should be afforded the right to appeal that decision to the Civil Service Commission, did in 2011 a different commission go along with what I view as watering down the independence of this commission that provides a perceived aggrieved party the opportunity to come before an independent body rather than, as you have very well pointed out, that only one officer has availed himself or herself to that process out of 3 or 4 that have been subjected to performance-based transfers.
Chairman Gazarian, no, this was not brought back to the commission.
I see.
Between 2008 and 2011.
All right, very well. I will open it up with that in mind to further questions, and I'll reserve comment right now.
Just if I can, I think that's where the problem starts. I think when there was a decision that took place in 2008 to have these hearings be brought to the commission, I think when that rule changed, and you confirmed that it never was brought back to the civil service, correct?
That's correct.
Was there any specific reason why?
Chair Gazarian, members of the commission, there really wasn't. I will apologize to this commission, and I think I would speak for myself, city manager, city attorney, but through the passage of time, lots of work and lots of things that occurred, we simply forgot that had been agreed upon, and the then police chief was very much in support of establishing this administrative appeal, which is a fairly common process, and that process was put into place, and as I said, utilized for that period of time.
And the other part of that question is this doesn't apply to any other department except the police department?
That's correct.
And is there any, I understand the POBAR portion of it, but is there any other reason why it only applies to the police department and not any other department in the city?
Well, it has to do with POBAR and the rights of an officer when taken out of an assignment and suffering a loss in pay.
So that's what triggers the...
Correct.
Okay.
Correct.
Got it.
Typically, a department head has the right to assign, reassign, move people, generally at will. But when it involves a police officer and the loss of pay, and if it's for a punitive reason or a performance-based reason, they're entitled to some form of an administrative appeal under the law. And
doesn't the fire department have similar?
Yes, they have a similar. In 2009, state law was amended to pass a similar. They call it FOBAR, Firefighter Bill of Rights.
Mr. Doyle, you know, and I will yield to you, Commissioner Devine. This commissioner has no problem with administrative appeals. What I have an issue with is when you articulated a moment ago that a different appeal process was implemented, much like a Skelly. My understanding of a Skelly is that a Skelly is not final, that the officer who is subjected or provided a Skelly opportunity may then seek Civil Service Commission review. Based on an issue that is not before this commission this evening, but was an issue that drove this issue before us, it appeared that on that situation, things appeared to have been final, or maybe they weren't final, but the person had not exercised the person's rights to come to civil service. But I am at a loss as to how parties can negotiate and take away that which is entrusted upon this commission by city charter. I'm at a loss. So administrative process is wonderful. It ought to be utilized so that matters do not come here as a first impression. But to deprive a party to seek redress from an independent commission, I believe is inappropriate under the circumstances.
Understood. And if I could just clarify, I didn't, when I said it was much like the predetermination hearing officer phase of the Skelly process, I wasn't comparing it to a Skelly process. As you know, the Skelly
right, you cannot, because it's not the same.
But the predetermination phase is where the aggrieved employee can go to their department head and or the city manager's office, and that's what I was comparing it to. And that's more or less the elements of the administrative appeal process.
If I may, just the last portion of my question was...
Commissioner Devine is going to speak.
Sorry.
Go ahead.
Yeah, just the last portion was, what is the city's position as far as now? What is it that the city would like to see, I'm just curious, happen to this process, to leave things the way they are? Or what would, you as the HR director, what, in your opinion, what should happen?
Mr. Chair, members of the commission, I mean, my opinion shouldn't prevail here. I'm staff to you, but I will say, given the cumbersome nature, the amount of time that we all know these hearings take when a Skelly process or a disciplinary action does come before the commission, I would say it would be a bit cumbersome to address transfers, assignments, reassignments in this manner, as far as the police chief being able to run the department and assign people and reassign them.
But but Mr. Doyle, a demotion or a performance-based transfer is precisely one of the main reasons why this commission exists, to provide overview for a party who believes to be aggrieved. I yield to you, Commissioner Devine.
Well, my two colleagues have really hit upon most of the questions I had. I think the first question I have, though, is should that issue have been brought back to this commission prior to implementing it?
Oh, absolutely. Absolutely. And again, that was an oversight. We dropped the ball, and again...
Then when you say it should have been brought back, how can you say at the same time that that process still stands? In other words, how can you say it's still valid or it's still in use?
I'm not saying it still stands.
If in fact it should have been brought back for vetting by this commission?
Well, this is why we're here tonight, to address that.
Okay. I feel the same way as my two colleagues based from their discussions. I'd like to read from the memo that the city attorney wrote to this commission back when we decided that it should come to the Civil Service Commission. It says, "We therefore propose that when a police officer is transferred for performance or disciplinary reasons and suffers a loss of pay, that officer should be afforded the right to appeal that decision to the Civil Service Commission." And then they make a recommendation. They say, "The matter has been discussed with the Director of Human Resources, Police Management, and the City Attorney's Office. All parties agree that based on the above cases," and there are a whole bunch of cases cited supporting this action, when a police officer is transferred for performance or disciplinary reasons and suffers a loss of pay, that officer should be afforded the right to appeal that decision to the Civil Service Commission. Based on that, I, for one, feel that it does need to come back before it's implemented any further. Also, in my reading of that process, and Mr. Manukian and I experienced it firsthand on a case that we had that was based on that, I believe, and this is my own personal opinion, that is the most unfair, inequitable policy as far as dealing with police officers, and I don't know how the GPOA or anyone else has ever agreed to even put that into effect. So with that in mind,
I'm sorry, can I just interrupt?
You may.
Thank you, Mr. Chair, members of the Commission. Michael Garcia, City Attorney. I think it would be useful at this time to, if I could allow Ms. Maurer to kind of give the background of how we came to you, because the policy, the report that you read from, for example, Commissioner Devine, there was a reason we came to you, because we were supposed to have some policy in place, and we didn't have anything. So we came to you, and I think it'd be useful for Ms. Maurer to kind of go through that background both of why we came to you, what the POBR requires, what our rules require, what the charter requires, and then frame the discussion in those terms. Because a lot of your questions, I think, will be addressed a little bit by providing that background from day one, why we first came to you, and as Mr. Doyle states, we definitely should have come back to you at the time we implemented the policy. But there was a reason that we did that as well, and we just missed that step. So I'd like to have Ms. Maurer, if she could, provide that background for you.
Certainly, I will provide Ms. Maurer an opportunity. Can you, before that, Ms. Maurer, can you reference what page you were reciting that from?
In the package that Ms. Garpetian prepared is Exhibit 9.
Oh, the exhibits. Okay, very well. Thank you. Ms. Maurer, please.
Thank you, Mr. Chair, members of the Commission. Prior to 2007, and I think actually currently, the GPOA MOU with the city provides that any special assignment is not permanent, that there is no right to the 5% pay that associates with that assignment, and that anyone can be transferred at any time and they have no right to appeal. That's what the MOU states. That's not consistent with the law, but that is what the MOU states, and that's what the department, I think, had been operating under for many years. And as far as I know, I started here in 2002, there were never any appeals relating to any transfers. So whether there were whether people just accepted and moved on, I'm not sure, but it just never was an issue.
So I'm sorry, I'm going to interject and ask a question. Because I didn't particularly understand. So what you're saying is that the MOU that's been adopted and implemented is contrary to the law as you understand it to be?
It has language in there that says that these assignments are not a right, that you don't have a right to appeal, and it specifically even cites this case, which I think you might have seen in the memos, White versus County of Sacramento, and it says, regardless of what that case says, you have no right to appeal. And that language was put in there. Both sides agreed to it, kind of, I think, understanding that it may not hold up if it ever became challenged, but it made people feel better, I guess, back in the day to have it in there, and everyone agreed. So that's what it said. And for whatever reason, for many years, it just never was an issue. Until 2007.
Ms. Maurer, before you go on, I'm sorry, I'm also going to interject so we don't move away from the topic.
I'm going to designate you as the messenger, and I'm going to ask that we don't target the messenger, though I don't know who was
I just want to clarify.
Go ahead.
I just want to clarify the issue of the MOU and the grievance process before we move away from what what my fellow commissioner already stated. A loss of pay and the grievance process. Does the MOU talk about loss of pay and an employee having the right to grieve that process? It may state that they don't have an appeal right, but does it state whether or not they have the opportunity to grieve when there's been a loss of pay? Whether it's a bonus removal, whether it's a disciplinary matter, does the MOU speak as to that?
I'm going to have to ask for some help on that. I'm not sure if there's a grievance procedure in effect for a loss.
I can answer that.
Okay.
Mr. Chair, Commissioner Tomian, the MOU does not address discipline. It does have the grievance procedure, but it's very broadly applied, and it simply says what the grievance procedure is, what constitutes a grievance, which is essentially a disagreement between an employee and management on a policy or interpretation thereof. But there's nothing specifically addressing discipline. There's nothing specifically addressing transfers or anything along those lines in the bilateral agreement between the GPOA and the city.
And I just want to clarify anything as to loss of pay.
No, as Ms. Maurer says, there's an article in the MOU which addresses all of the specialty assignments and the 5% that everyone gets if they're assigned to those. And there's language that's been in there for a very long time indicating these assignments are not permanent assignments and they don't carry with them a property interest right. It's not like being promoted to. A good example would be we used to have many years ago a job classification of police detective. And it was a job title, and if you were removed from that, you got a Skelly hearing. And probably 20 years ago, we eliminated that job classification and made the detective an assignment for this very reason, so people could rotate in and rotate out. So.
Thank you, Mr. Doyle. Thank you, Ms. Maurer. I didn't mean to interrupt, but it is definitely contrary to what the law is.
Before you continue, Ms. Maurer, Mr. Doyle, when we talk people move in, people move out, I believe in getting everybody a fair opportunity in and out of departments, specifically in in a law enforcement agency. But you would also agree, and I'm sure everyone would agree, that public policy dictates that we have the best people in the best positions or in the right positions, and we do not move people in and out in the interest of giving other people an opportunity to learn when there's a dire need for a specialized, trained and experienced person in a particular unit to remain perhaps until such time that somebody equally qualified can take that position or sufficiently qualified. When we talk about best interests of the public, and I keep now over and over seeing MOU-happy unions or POBRs or whatever, MOU this, MOU that, which at the core of it looks to undermine that which the Charter provides as a basic ground level process, grievance process, due process. Those MOUs, that's why I initially asked my initial question, and I would ask Ms. Maurer at some point to address that. Does the city of Glendale now believe that public policy and the best interests of the city and the citizens of the city, as well as the employees of the city, specifically the police department in this case, are best served by leaving the process as the Charter provides for, or otherwise I suppose the city can move to amend the Charter, leaving it as it is rather than going the path that because parties to an agreement agree to it, we're going to now dilute the rights of those that are affected by it? Thank you.
Would you like me to address that first?
Please, at some point. Yeah.
I mean, I think it is our position at this point that everyone's rights will still be served by this administrative appeal process. It is a less formal process, but there's still witnesses are called. In the case, I did handle the one case that we had, and I called one witness from the city who basically laid all the groundwork for the reasons that we were transferring this employee. And then the employee, I believe, in that case, he testified, but he could have called 20 witnesses, and there's no limit to the number of witnesses he could have called, and we both were allowed to submit evidentiary evidence that was all considered. So, and that was a performance-based transfer.
And who was the hearing officer for that?
That was Yasmin Beers, the assistant city manager. And it was held in here, and there was a counsel, I think it was Mr. Harold Potter, who was there to advise Ms. Beers. So it wasn't just in her office like an informal Skelly hearing where she's asking casual questions. It was a more
But even if it was an informal or it was just like a Skelly is not final. Skelly process provides that the party may seek independent review. Our city charter provides for that for those who are discipline-based, and performance is exactly that. If it's a performance-based transfer, it's a disciplinary transfer. To say they're going to have the same rights, I would most respectfully disagree with that conclusion on your part for many reasons that I can be here all night with, but I won't.
I don't believe the charter addresses this type of transfer with a loss of pay. I do not believe that's in the charter.
Well, it does, because in the charter, I will direct your attention to Rule 10, subsection B. It says disciplinary actions include, and at the very end says, and temporary or permanent reductions or classifications or pay. And because a transfer from a detective bureau results in a 5% reduction in pay, if it is performance-based, it is subject. Therefore, it's disciplinary. And if it's disciplinary, then therefore it's Rule 10, subsection B. Therefore, it's charter protected.
Are you reading from the civil service rules?
Yes.
Okay, I thought you were reflecting what the charter said. You said the charter.
Well, yes, but the civil service is a charter-based commission, and you understand that the authority of the civil service is derived from the charter, and the rules are to implement that which the intent and the purpose of the charter is.
Right.
At least that's how I look at it.
No, I know. I'm just being very specific. I think the civil service rules are a little more broad than what the charter provides. That's all I was saying.
Well, of course, clearly. That's why we have the rules to further elaborate on what the charter's intent is thought to have been.
And so just to kind of backtrack to the Chair Gazarian's question, so your answer is yes, essentially.
We believe the rights of the employees are still being protected because it is a hearing process.
Well, I'm sorry, with all due respect, that wasn't the question. The question was, is the city's position now that the administrative hearing should be the procedure used?
That is what we're requesting, yes.
Is there an appeal to that process?
There would be an appeal to the Superior Court, just as if it was before the Commission.
But isn't that diluting the Civil Service Commission's right to hear discipline-based transfers?
I'm not debating whether or not...
But isn't it? I mean, it's a direct question.
I don't think it's diluting it because we're giving them a process. What we're trying to do is...
You're unilaterally giving them a process when that process belongs to them by charter vis-a-vis the Civil Service Commission rules, and it should be us, the Commission, or whoever sits here as commissioners, that decides that, no, the Commission should not be listening to these things. We should dilute our own power, which would be improper, in my humble opinion, because it would be dereliction of duty by this commission to do that.
Chair Devine, I'm sorry, Chair Gazarian, if I may.
Yeah.
I think that's what is being sought here is further clarification of the rules, and perhaps you want to go back to hearing Ms. Maurer's presentation so you can hear the balance of why we ended up here, and I think that's where she had started, and maybe we got off track
I'm happy
there.
to hear from Ms. Maurer, but we sort of got to the end before the middle because we're interested in the end.
Right.
And in the end is that any way we slice it and whatever you will say, and I'm happy to hear it and I want my colleagues to hear it, what you are saying is all intended to bolster that which, at least I can speak for myself, I can't speak for others, you can assess where they're coming from. I find it to be improper, not to use the word illegal.
And I think, I'm sorry.
I'm sorry. You know, we had something similar early on when I took this seat here, and my position remains consistent. It seems like I'm less interested in debating what the city believes to be the right process, which I leave to the city's discretion, because certainly you know more about what the best way of doing things is than I do sitting here. My only concern is that, in my opinion, I'm not going to use the word dilute, I'm going to use the word contradict. I think that the procedure contradicts the civil service rules, and if you do wish to change it, then I think that an appropriate amendment should be made. It shouldn't be just, you trying to convince this commission that what you're doing, even though it's really not in the rules, it's still the right way and it's still fair and whatnot. I mean, I think that is the appropriate and procedurally correct thing to do.
I think I'd like to hear...
Mr. Garcia?
I'm talking. One
sorry.
second.
Go ahead.
I'd like to hear her presentation.
I'll let the commission hear it. I do want to address that point.
You may address that point, and then I will resume with the presentation. Please address the point so we don't forget the point.
I think at the end of the day, the reason we're here is because there's this particular policy outcome that the staff management is recommending, which is to have a policy where this policy is in place. And we don't see any reason why you shouldn't amend the civil service rules just to clarify that would be the policy. We have some really valid legal reasons for thinking that it's already permitted under both the charter and the rule. But if at the end of the day the commission disagrees, then our position would be let's direct staff to amend the civil service rules and put this policy in place via the civil service rules.
Is that what's being requested today? I mean, that's not on the agenda, right?
It's not specific on the agenda for a rule amendment, but
Okay.
at the end of the day, we're taking the view that both the charter and the rules would permit this policy to be in place. If the commission wants or disagrees with that position, certainly then the recommendation is then to direct us to, and the commission's okay with the policy being in place, then the recommendation is for the commission to direct staff to prepare a rule change.
What if the commission believes the policy is not proper and should not be adopted?
I think our position has been that because we came to you, to the commission, to have these matters heard before the commission, and the commission wants to retain that authority, then the commission would retain that authority. But again, there's a long presentation here that also includes comments from Chief Castro that we think you should hear
And would like
making that particular decision.
I think I also would like to hear from Chief Castro after the presentation, and also the GPOA. Hi. Okay, I'm sorry.
I just wanted to give you a little background so you understood. Like I was saying, we have the MOU in effect. No one's raising an issue until 2007 we had a sergeant from our air support unit transferred from air support for performance reasons. And following the MOU, I think someone just went to him and said, "You're being transferred. You're going back to patrol. You're going to patrol." And Mr. Cheney became involved in that fairly early on and filed a lawsuit against the city saying we had violated the sergeant's due process rights, we hadn't given him notice, we hadn't given him an opportunity to appeal. And we kind of all looked back to the MOU and said, well, wait a second, he doesn't have the right to appeal. And then we started researching it and going back and forth with Mr. Cheney and realized, in fact, the MOU did contradict the law to some degree. And in fact, because this was performance-based, it was per se disciplinary, and he did have a right to an appeal. Now, under the government code, 3304 says you have a right to appeal, but it does not set forth what that appeal needs to contain or what it has to consist of. And case law is kind of all over the board on that. It says...
Keep in mind when you talk appeal to a neutral party, correct?
Yes.
Right.
And
just let's keep that in mind, because
yes.
I have an issue with that. Okay.
Yes, and there are many cases addressing it where people tried to send someone to the chief of police or the city manager, and they said, no, that's not good enough. But an outside arbitrator, that's fine. A civil service commission, that's fine. You know, you have to give people the right to present witnesses, the right to cross-examine in certain cases, the right to present evidence. So it's more what you provide versus the body that hears it. So based on that analysis, we said to ourselves, Mr. Cheney is telling us basically that we have no right to appeal. And in reading the MOU, you know, we kind of looked at it and said, yeah, it says permanent reductions or permanent reductions in pay. And considering that this specialized pay wasn't necessarily a permanent type pay based on the MOU, we agreed with what we thought Mr. Cheney was saying, that there's no right to appeal to the civil service provided in these rules. And that's what prompted us to come here to say we do not want to have a lawsuit. We do not want to have Mr. Cheney be able to get some sort of order saying we're violating due process. So Ms. Marino and I came to the commission at that point to try to clarify that, no, look, this is our mechanism that we're going to provide you. You can come to the Civil Service Commission. We were still discussing whether or not that was the best or that was the only, the only way we could do it, but at the time that was all we had available. We didn't have any admin appeal procedure, and also almost simultaneously 6 months after this.
But you did have Skelly procedure.
But yes, but that is not.
That's an admin
not
procedure.
Sufficient. No, I mean they need a hearing. We needed to provide a hearing.
I see.
And
okay.
So the only mechanism we had
stand
at that
corrected.
time was
Yes.
civil service. Within 6 months of the sergeant transferring out of air support, we had another pilot also transferred out, again for performance-based reasons. And that was in July of 2008. I'm sorry, in May of 2008. So with those two, we have one lawsuit, and then we have another officer being transferred, who at that point we didn't have any right to appeal. That's what prompted us to come to the commission and try to solidify that we have this procedure. These two officers could come to the civil service if they chose, and we thought that would then prevent a further lawsuit from the second officer. And then it was in June of 2009, roughly, that Chief Adams retired. Chief DePompa was about to take over, and he felt very strongly about his right to transfer officers and sergeants and move people around in the department. And I've worked in outside counsel for many law firms, and I've heard, not many law firms, for many departments, and I've heard that from many chiefs, that they always feel they should have that right to move people around. I mean, it's their absolute right. If they feel that this sergeant would be best in that spot, they should be able to put him there. Well, this 5% threw a big wrench in that, because all of a sudden moving someone gave them this right to appeal. So Chief DePompa felt strongly that, look, I understand civil service is there, and that's a fine option. We have suspensions or terminations. But when I transfer someone out of a unit, I need to move that person out, and I need to move someone back in, and I need to get that person up to speed. And I can't have these drawn-out processes that, not attacking anyone, but a lot of times the appellant, a lot of times us, a lot of times the commission. We just cannot all coordinate our calendars. And we're looking at 6 months, 8 months. And for these types of hearings where the chief wants to just get someone, move someone out and move someone in, we felt, is there some other process that might be more expeditious? And so that was why in June or July of 2009, Ms. Marino contacted Liebert Cassidy, who is kind of our go-to firm on employment matters, and said, what are other cities doing? Are there other processes? And that's how we got down this admin appeal process, because they said, yes, in fact, other cities use this, and they sent us all the different rules. And that's what prompted us to then start going down that path again, as we've all reiterated, at that point we absolutely should have come back here and said, here's what we're thinking, here's why we're thinking it, but none of us can recall what we were thinking and why we didn't do that, and we apologize also for that. But we went down that path, we drafted that, we met with Mr. Chenet, we worked out some kinks, and then for whatever reason, because no one was appealing and there were no transfers, it kind of just sat, and we never finalized it. And then all of a sudden we had the transfer of Sergeant Mardikian, and that's what then brought this back to the forefront, and we said, okay, we have to finalize this policy now to get it into play. And so we then worked to get that done, and he went through that process in early 2011. So that's kind of how it came to be. And I think Chief Castro could explain to you why he still feels that having some sort of more expedited process would benefit him and the department.
I'm going to yield to Commissioner Devine, but I will say this in brief response to what you just presented. Thank you for your presentation. I could see the frustration that a chief would have in not being able to be a chief and run a force. However, when you provide any individual who is perceived, he or she perceives to have been aggrieved with what we all hope to be a true appellate process, one that is by a neutral party. A neutral body is made up of five such parties, and regardless of how many hearing officers are assigned to any particular process that has come before this commission, in the end, five of us, unless one of us recuses himself or herself for whatever reason, five of us try to reach a consensus which, agree or disagree with, the parties cannot possibly question our neutrality as a whole, as a body. I believe that in the final analysis, when a transfer is made, to make it quick, I believe all such prior transfers or terminations of employment or all the like that have occurred have been in full force and effect until or unless this commission has disagreed with that move or decision that has taken place. So I don't see a real disconnect in our dear chief making a transfer, and if the person really thinks that it was an improper transfer, a disciplinary transfer or retaliatory transfer, to allow that person to seek the redress. If they are correct, that's one thing, but whether they are correct or incorrect, however many months go by, as you said, because of our respective schedules or not, the transfer will have been in place from day one until such time that there's a contrary decision made by a hearing body, which I believe, under all of the circumstances, ought to still be the Civil Service Commission, regardless of whether or not I'm a part of it. Thank you.
Ms. Maurer, thank you so much for your presentation. And Chair Gazarian, I think the word transfer here is being used loosely because we all know, I mean, having worked for 3 different law enforcement organizations, currently working for one of the largest ones, I think there's transfers, there's punitive transfers, there's bonus removals, and each one should be addressed separately. And I also believe using the word appeal process, internal appeal process versus a review process, should also be differentiated. Because I can tell you that most law enforcement agencies do have an internal review process. They don't call it an appeal process because they don't have a neutral body that's going to, especially in a smaller agency where everybody kind of knows one another, it's very difficult to create neutrality. Civil service provides that. It actually provides a layer of protection for the city. That's why I encourage city officials to seek the Civil Service Commission in finding neutrality because for an appellant, it takes away a lot of their arguments if they've been wronged and they take it across the street to Superior Court. So internal transfers, yes, we can call it a transfer, but there's several different types of transfers within a law enforcement agency. So that needs to be differentiated. And also in the recommendation portion of the city attorney's moving papers, transfers based on performance or disciplinary reasons and where there's loss of pay. that also should be broken down. Because if you're looking at performance-based transfers, then you have to look to see, A, is the employee on probation? Then you don't have a problem. Then all you need to do is document and move that employee around and or release that individual. If it's a performance-based transfer where the individual is on a bonus, then internally you can create a review process where it's a grievance process. And if the employee can move that up the chain, it can go all the way up to the city manager. And if the city manager and the chief concur, then ultimately that individual still can seek the Civil Service Commission in finding neutrality. And again, to find neutrality takes away majority of their arguments once they file a lawsuit and say, I've been discriminated against, because they come to this body and this body looks at it. If you have a disciplinary-based loss of pay, then it's got to find its way to the Civil Service Commission, right? I mean, there's no ways about it. If you create an internal process, appeal process, it's not going to work. You can have an internal review process, which most law enforcement agencies have. They have a panel of high-ranking members who have plenty of experience, who review cases based on decisions that lieutenants or captains make. And they review all those decisions and they come up with their own findings. And that itself can move up the chain. It can go to the human resources head, it can go up to the city manager for final approval. But ultimately, to have neutrality within even a smaller organization is so difficult to find, and it's so difficult to defend when you have lawsuits of retaliation, because everybody within a small organization knows one another. There's a chain of command in a law enforcement agency. It creates such a difficult burden to find neutrality. So I think if you look at it as a review process versus an appeal process, and if you look at transfers in different realms, you may be able to find both, where you have a review process internally based on the type of transfer that you're dealing with. In addition to that, not take away any authority from the Civil Service Commission. And this isn't about authority, but mainly, again, I encourage city officials to look at this as a way of protecting the city in providing this open door type of a thing where, it could be reviewed by a neutral fact finder. Most of the individuals who are up here, from my understanding, don't have any type of a connection within city departments in regards to the employees that are come up with any type of a disciplinary matter. So we provide that neutrality. But in a small law enforcement organization, I got to tell you, I've worked for them. I worked for large ones. I worked for small units. I worked for so many different units within different law organizations. It is almost impossible to try to find that neutral body within a law enforcement organization that's going to look at it and say, yeah, I've never worked with this guy, or I've never heard anything about him, or he's never reported to me, or any of that stuff. It's going to be so difficult. So why not create a review process internally and create an appeal process externally?
And we do that with Ms. Spears on the Skelly level, but there have been many occasions where Ms. Spears has taken the proposed action by the police department and reversed it. So
really?
It's not that she's the rubbers. Yes, she's sent back a termination. I know there's been terminations, suspensions where she's reduced things. She's not a rubber stamp of the department.
No, I don't think anybody's claiming
to work
that.
that
I'm
way.
saying, so for the process that we set up, we make special sure that she is not involved in any discussions about these employees. We go the extra mile. Sometimes in other cases she is involved at the ground level, but anything where we think it's going to end up at a hearing before her, we make special effort to make sure she knows nothing about it, that no one has spoken to her, she hasn't reviewed any documents. So we do make efforts so that I understand the officers may still not think she's a neutral, but under the law she is at that point because she has no knowledge of what has gone on.
What is that?
Why not though take away that argument by affording that opportunity to a panel that is going to create a quorum? Why not take away that argument from an appellant who's going to come and say, I was retaliated against, when you have 5 volunteers here who come sit here day in and day out without any type of a cost to the city? If you guys get a hearing officer, I'm sure they're not volunteering their time, who care for the city, who are residents here, who care for the well-being, the financial aspect, the outcome of the city. Most of us have grown up in this city. We live in this city. We have kids in this city. Our kids are going to go to school here. They're going to get married in this city, and they're going to have kids in this city.
It's not about the argument.
Why not take away that argument from, the appellants who come up and say, I've been retaliated against, when you have a panel of 5 members who are going to say, no, that wasn't the case.
It's not even the argument. You just touched on a very sensitive issue. You said, in the eyes of the law, she's neutral. The officers may think she's not. I am certain that she's capable of being neutral. But what does that do to the morale of the police department or the police officers when you tell them you can only go to our administrative division of the city? You cannot go to an independent body. Clearly, by now, none of us answers to any of you, so we are independent. We may make decisions that you may agree with or disagree with, but we clearly are independent, and we vote our consciences with issues. No one can say otherwise. I'm going to ask Commissioner Ms. Yakubian. Go ahead.
Fine.
Are you fine?
Yes.
Okay.
I'd like to just add on to one thing. That discussion. We've been talking about the hearing officer and Ms. Beers being neutral and everything, but in Section B of the administrative policy, it says the chief of police or the city manager may adopt, modify, or reject the hearing officer's recommendations, an advisory decision, and the chief's or the city manager's decision shall be final and binding. So regardless of what in this process, regardless of what the neutral hearing examiner does, in this case, again, it was Ms. Beers for this case, the bottom line is going to be if the chief doesn't like it, why, he's going to go his way. So that is not neutral or fair.
The administrative appeal procedure, because it's Ms. Spears that would be the hearing officer, so her decision is final.
No, it's not, according to this.
I seem to recall that this matter was supposed to be heard previously, and you were unavailable, and I was much more prepared, frankly, then. I seem to recall that it left me feeling as though one side did not really have recourse. And recourse, at least the availability of recourse, renders the city less likely to be culpable or subjected to litigation, which is something my colleague, Mr. Hatamian, mentioned, that I find it to be very, very, very valuable for your department to consider in the grand scheme of things.
But, Chair Gutierrez, can I?
Yes.
Just one comment that I wanted to make. As far as I'm concerned, I would like Chief Castro to have the ability to run the department the way he needs to. Having said that, I don't have a problem with the way the city is recommending to handle this, with the understanding that ultimately, if the employee wants and has the right to appeal that decision to this commission. To me, I think taking that, I don't see how an employee benefits when you take that appeal right away from them. And honestly, I don't even know how the GPOA would agree to something like that, in a sense that, with all due respect, Ross.
Mr. Ross, Sergeant Ross is not paying attention.
Jason Ross was
So it's all Ross's. Jason, it's all your fault. So to me, I don't have a problem with the way it's being presented, because I would like Chief Castro to run his department the way he needs to. But at the end, the last stop, if the employee still needs to appeal that decision, I think they should have the right to. That's my opinion.
We're confident that Chief Castro will come and make his case if that came to pass. We would like to hear from Chief Castro, by the way, so I want to make that known. Yeah, go ahead.
Just a quick comment. Commissioner Manukian, and correct me if I'm wrong, Ms. Maurer, for the business needs of the department, if it's not a bonus removal, the chief has the authority to run his department as he wishes in rotational transfers. Am I correct?
Yes.
So it's not going to take away the inability to transfer people. We're merely talking about bonus removals where there's a loss of pay associated.
Which is everyone that's not in patrol.
Exactly.
So
I just
anytime
want to
someone from
clarify
detectives or any specialized unit, if he wants to move them for performance or discipline,
Thank you.
they would have the right to appeal.
Okay.
Yes, we would like to hear from Chief Castro, and there's water in these things if you'd like to have some.
Please take this gun away.
Thank you, Ms. Maurer.
Thank you, Chief.
Mr. Commissioner, members of the Commission, what I am looking for is the ability to efficiently run the police department. to have accountability and transparency so that the entrustments that this community and the governing bodies that make up the city provide for us to provide public safety. The job is very complex, as you're well aware of. There are many different things that go into making public safety work properly. One of the key issues is for management to ensure that we have the proper development, the proper placement of personnel within the organization. I am looking for a process that allows me the ability to transfer personnel to positions within the organization that best fit the needs of the community's safety needs, and also allows for the development of an organization, because there is turnover, and if we do not forecast forward and develop personnel and spread out the wealth of knowledge and experience, an organization will become stifled. An organization of this size, it is not going to best serve the community to have permanent special assignments, because those people will eventually retire from the organization, and the learning curve to get new people up to speed would greatly impede the effectiveness of the organization. The steady flow and movement of personnel in a very strategic manner allows for the efficiency of the organization, allows for us to provide proper public safety services today as well as tomorrow. My job is not only to provide public safety today, but to ensure the decisions I make now and in the near future will work 5 and 10 years out beyond my tenure within the organization. Saying that, I need processes that allow me to move people, and if there is a process that needs to be heard, to review that movement, that it is done expeditiously, that it does not hinder the organization's movement. As months go on and there is uncertainty about the finality of our management decisions, it creates a loss of productivity in the organization. It affects morale. And you have uncertainty about, am I going to put a new person into that assignment where one has been transferred, and then what is the finality or the future of those two individuals, and everybody else worries about it. I am seeing things that are problems that we've had in the past within this organization. A lot of them stem from transfers. A lot of them stem from processes that were too long and cumbersome in terms of being able to get them finalized. If we are going to have review processes, we need to make sure those processes are done quickly and expeditiously and not drawn out, and heard in a way that, yes, affords the employees a fair and look at what my decisions are and why they are. When it comes to discipline-based transfers, those obviously should probably have a deeper level of review, because we are taking something away from an employee. We are moving them for a disciplinary reason. And I can understand why those type of movements would be considered something that needs to have a little deeper review, because it's being done for disciplinary reasons.
Thank you. I will reserve comment. I know you want to address the chief.
Chief, thank you. I certainly understand that you want to be able to smoothly and expeditiously run your department, and I think everyone here supports that. We're only looking at a small piece of what happens in your department on a daily basis, and only looking at what the government code basically says is subject to review, and that is something that is punitive, that requires an administrative appeal, and something that includes a reduction in pay. We agree on that, correct?
Yes.
Okay, so is there a particular problem that you can identify in these small percentage of cases where that party falls into this particular scenario and feels aggrieved and feels like he needs to undertake in that administrative appeal process? Do you have an issue with this body reviewing that rather than the city or the assistant city manager?
Whatever process would allow me to run the organization quickly, in the most expeditious manner,
I wrote that word,
and allow us to be able to get the process done. I don't believe that there is an inherent problem with review above my decision being appealed to the city manager's office and making the city manager's office making an independent review of my decision and based on my findings. There are also review processes that can go beyond that, and that is a writ to the Superior Court, or if there was a process where beyond the city manager's office it was brought back to your body. But whatever process that is, it needs to have quick finality to it so that we can be able to move the organization forward. And if that can be accomplished, those are my needs to run the organization. In terms of exactly the process that occurs, my opinion is that process just needs to meet my needs. And I'm asking for that help and that support to allow me to move the organization forward.
Commissioner Manoukian?
I think I heard you say, basically, as long as you can move the people that you need to, and whatever appeal process happens, as long as it's done in a timely manner, that'll resolve your concerns. Is that?
Yes. And when I talk about a quick manner, I'm saying that the review process needs to occur within a finite number of days. Like we have a 14-day window where the appeal process takes. Because, again, we can't have things. That's what's caused some of the hindrances currently in our organization.
Not from this.
No, I'm not saying from this body, but I'm saying processes have been slow sometimes, and that's caused, I think, some of the issues that we have faced in the past, and that causes. It's everything with discipline. Sure. We have smoothed out the disciplinary process in the department because we had investigations that were long and drawn out, and all of them at the end of the process, we found no misconduct by the employee. But when you make an employee wait for 9 months of uncertainty, that employee is distracted, and it takes away from their productivity. It takes away from them concentrating on the job. And so I am looking for processes, I'm looking for support so that I can move decisions quickly. I can have finality to them. And if my decision is upheld, fine. If my decision is overturned, I can live with that also.
I think that leads me, but Mr. Doyle, can you remember in the history of this organization, for as long as you've been with them, ever on any case that it's lingered on because of this commission? Has this commission on any case, previous history, caused a delay for an appeal hearing, for example? Because I just want to clarify these concerns that that our chief brings up has nothing to do with the Civil Service Commission. But we completely understand your concerns of having to run your department. And I can tell you the appeal process has never been hindered from this commission, not unless you tell me otherwise, Mr. Doyle.
Chair Gazarian, Commissioner Manoukian, it is a fact that when, and I assume you're talking about disciplinary cases because none of these transfer cases.
Correct.
When a case does come before the commission, and it's not the commission's fault, it's not anyone's fault, but the process where you have multiple
attorneys,
hearing officers, you have multiple counsel, you have counsel advising the appellant, the appointing authority, you have a counsel advising the commission as far as witnesses availability. It is factual that these cases do drag along, and I give great credit to the commission. I have to say, you folks do your best to move these things along, but the bottom line is they do go on for month after month after month. We have a current case right now, a closed hearing, that is taking several months. And again, it's no one's fault in particular, but the fact is aligning calendars, working around vacations and court and all that other thing. It does take a while.
But my question is, does that change if the hearing officer is different? You still have the same attorneys, you still have the same number of people that need to coordinate that. To the base of my question.
This is not the issue.
Well, it is when I ask a question, it is an issue. One of the things that we're hearing is that we're taking way too long for these hearings.
I didn't think the chief said that. I didn't think the chief
sorry?
said that. I didn't think the chief said that.
No. I'm not saying the chief is saying that. Okay. But the justification in wanting to do this is because, not coming from the chief, but from the city attorney's office is they want to do it. This process is because they want to expedite the process. I mean, that's one of them.
Well, actually, that's a good
One at a time, please. Go ahead.
I just have one question. How many cases are we talking about in a year? I've been on the commission almost 7 years now, and I can only remember 2 cases where there's been a transfer issue. So I'm not sure whether we're really creating a monster here and trying to craft something that applies to maybe 1 case every 2 years. So I'm going to ask the chief, how many of the transfers have you made since you've been here where there's been a reduction in pay? Have they grieved or complained about?
There's been one. And talking to that employee, working with the POA attorney, the employee did not grieve, did not skelly it. We were able to come to a resolution on that transfer and the reduction of pay without any issues or need for appeal.
That's great.
And I can tell you that that is my intention in the future, is to find ways that we will make sure that we're affording every opportunity for an employee to be successful before we'd ever get to that point where the disciplinary transfer would occur. At that point, under my management, it's never going to be a surprise, and they are going to be afforded every opportunity, be it training, be it whatever opportunities we could possibly afford them. Now, if it's a disciplinary transfer because of misbehavior, that's a little bit different. But as I've said, we have already implemented a new disciplinary system in the organization. We were affording employees opportunities for training for small mistakes to learn from them, education-based discipline, where a small mistake is used as a training opportunity, and we afford that employee the ability to rehabilitate and learn from those and hopefully avoid some of the larger mistakes of the past. So I can tell you that it is my sole intention that you would not hopefully see any of these type of transfers come up before you or having to be addressed. Is that a lofty goal? Absolutely.
Okay.
But I'm working closely with the POA. I have a relationship. For many years, I worked with Attorney Dick Cheney previously when I was a POA board member and he was the representative for my union back in the day. So we have a good working relationship of trying to find ways to improve this. These processes, I can tell you, are the most distracting thing for an organization. Is morale is affected so deeply, probably more so than pay and benefits, is how we handle our employees' discipline, their development.
You are absolutely correct.
And the equitable allowance of people to develop themselves and have opportunities to succeed and maximize their potentials in the organization.
You're absolutely,
I'd like to say to that I have noticed since I've been on here since you've been here, a marked decrease in number of cases coming to this
Our customer base is going down.
Lay at your feet because of this attitude you're taking. I think it's wonderful.
Yeah.
But my question is, based on that, and the number you just mentioned, you had 1 since you've been here with the transfer, would it be difficult or would it be a hardship on your organization if we did not use this administrative procedure, use the one that's in the code at this time, would allow the 1 or 2 at the most cases a year to come to this commission and have it adjudicated maybe instead of a month, it might take 2 months to get it resolved. Would that be a horrible hindrance on your operation?
I would say 2 months is too long, in my opinion. And I'll give you an example. The transfer that we did do, and there was no appeal by the employee, that transfer didn't just affect the police department. The assignment also worked very closely with stakeholders in the community. So the actions weren't just internal, and they weren't just perhaps actions that affected a citizen that was, mistreated by an employee. It affected an entire stakeholder group where we had to take immediate action and remedy that as quickly as possible. And when the employee was brought in and we explained the facts of why the behavior was unacceptable, not only within the organization, but what it did to our image and how if we didn't take immediate action, it could have a long-term negative effect on a long-term relationship that we had built and an entrustment that we had built with this stakeholder group in the community. And a 2-month delay in that, where either I couldn't fill that specialized assignment that needs every single officer assigned to it. So either, again, if I just transferred the officer out, I would not really feel real comfortable putting somebody in until I knew there was finality to it. Bringing that closure quickly within 2 weeks. If we have all the facts together, enough information to say, I can make a decision and this is the decision, I need some sort of review in a very rapid manner so that that can come together. And working with Dick Cheney, he wants that same thing. And understand, if an employee comes and says, here's the data review, whatever the process is, and he says, my attorney can't make it, it's been my practice to say, you can have representation, but maybe you get somebody else from that firm, and let's get this done, and get this over with. I've experienced tactics that sometimes are delaying and all that, and we need to get it done. The employee wants to know what the finality is of it too, and so whatever the process is, it's got to work in that manner for us. It's very critical if you're going to allow me to move this organization forward, because this has been, I'm not saying it's this body, but there has been delays in many aspects of the organization, and it has had a negative effect, in my opinion, and I am trying to remedy that.
The dictionary may speak for the GPOA, but oftentimes I think invoking the city attorney's name probably will carry more credibility before this commissioner than Mr. Cheney, and I've said that publicly and privately. That doesn't mean much to me. What means much to me, Chief, is what you're saying. You want speedy resolution, and one way of providing that speedy resolution, yet not running afoul of the rules and the charter, the way I believe the charter does mandate this commission to have jurisdiction over such matters, is for this commission to assign one hearing officer for such performance-based transfer grievances that may come before it, and that one hearing officer may very well do that which an assistant city manager may be able to do, because it's a one hearing officer without having to coordinate with the schedule of others, but it will provide one additional layer. The additional layer being that 5 commissioners will have to sign off on it, or a majority of the 5 will have to sign off on it. And in that scenario, I see that process taking place, in my opinion, quicker than 2 months at the outside of it that Commissioner Devine alluded to. I have to say also 2 things. Death penalties take a long time, Mr. Doyle, but we are dealing with someone's life. Here, though none of this is someone's life, but it is. It is someone's careers, or many people's careers that are affected, Chief, by decisions that you may make, by the decisions that an overseeing review body, as Commissioner Hatamian said, or an appellate body, as Ms. Maurer said, or I referred to it. So, whereas I am mindful of your desire, and as well ought to be your right to run a department quickly and expeditiously and efficiently, I am not about to forget about the individual's right to at least have the process that which is in place be afforded to that individual, because if that performance-based transfer, at a minimum, disciplinary or whatever you want to call it, does nothing else, it certainly holds that person back from advancing, and to me the American way is to continue to advance. And I don't want to be a part of hampering that, and I know that you don't want to be a part of that, but I am mindful of your desire to make it quick. And I wrote it out that, a one hearing officer assigned by a civil service commission, then approved by the full commission, does exactly that, yet protects not only the city from someone ever saying, well, that was just the assistant city manager. She's just across the street. She knows all the managers. She knows all the command staff. I mean, really, whose side is she going to believe? I don't know. If I was in her shoes, I'd probably put more credibility as to the management as well, because I would probably have more dealings with the management, and their credibility will have built up over the years. It would be difficult for me to say I can really be neutral. There was a hearing in question here. A person had one question posed to me years ago. I don't recall the question. It was a legal question. I have no friendship with that person. I don't even have a social relationship with that person. Yet I recused myself from that process. So how could someone who has dealings with command staff on a daily basis not be susceptible to, at least even unconsciously, giving more weight or credibility? I hope that there are such people, but in my line of work, judges oftentimes recuse themselves when they come across such parties. So,
Mrs. Beers, we love you.
yes, no, nothing personal. She knows that. She knows that. It's all about the perception, and the perception not by me or by you or by the city, but that one supposedly perceived to be aggrieved party that will, under this scenario, will not come to this body, but will go from that appellate or review process directly to Superior Court. Well, really, I mean, I pay a lot of taxes in this city, and I really don't want to be seeing all that money going out, or at least being subjected to going out. Anyway.
Thank you, Chair Gazarian. I just want to make a few comments, Chief. Thank you for being here. I know we've talked about EBD before privately, and it works wonders, and I'm really happy to see that it's working within Glendale Police Department. However, I've also seen other similar things that have worked also when it comes to transfers and bonus removals and so on. I've seen rotations for management positions and bonus positions where the chiefs have set a rotation, so therefore you don't have brain drain, meaning all your managers will rotate, and I'm sure you know how that works. Also transfers for just the regular personnel who don't have a bonus position. But it seems like you're more concerned with an expedited process for bonus positions if you have an individual that may have a disciplinary issue and or is not fulfilling that specific position's requirements or is not performing up to standards. And as Chair Gazarian said, I know in the county that's what we do. We have a hearing officer. It's appointed by the commission. It's not appointed by the internal body. And once a hearing officer gives a report, then the commission, having a quorum, either adopts it or doesn't. We also have an internal review process that's an outside uninterested commissioner that will come in and take part in the review processes as well. Also, documentation helps. So if you have a bonus position where the individual is not performing up to standards, holding your management accountable that manages that bonus position to continually document will definitely strengthen your case when time comes for you to either transfer and or remove that individual. Negotiations with the unions, that also comes in very, very handy, that within your MOUs, if you can put in language in regards to transfers so you have a little bit more authority, especially since you're kind of working with Dictionary in regards to doing more EBD.
What is EBD for us who are not...
It's education-based discipline, and I believe the Chief lightly touched upon it, where you choose to train the individual who lacks performance issues versus just disciplining them. So you send them back to training, and mainly it's just performance-based. You don't do that when they have general behavioral issues.
Okay.
But those are just some other suggestions that I've seen. Again, you have more experience on your pinky than I do in my entire both hands. So whatever you think will work, we're there to support it. And I believe Chair Gazarian's recommendation will work. I may not be here when that all takes place, but...
I may not either.
But hopefully it will work for everyone.
And I can tell you the suggestions you've made, many of those are already in process, are already being discussed, are already being looked at. And when I talked about wanting an expeditious process, it's not just for me, it's for the employee. Yeah. Because I will sleep at night or not sleep at night because of my concerns. But I don't want the employee, the affected employees, to be having to worry and have this uncertainty. Because I have seen it as a chief. My experience has shown me that it is absolutely detrimental to the organization. It slows down productivity. It hurts morale. It is one of the most upsetting things to an organization, is getting things done quickly in terms of finality. What is going to be the outcome of this? And I can tell you this. It is my style, and it has been my history and my practice to make sure that by the time an employee gets to the point where there is going to be a disciplinary transfer, they have been given opportunities for performance improvement plans in written document with very specific guidelines. They've been given opportunities for training, and we put it on the employee. What can we do to help make you successful in this process? Obviously, they showed a skill set that allowed us to give them that opportunity to work in that assignment. What has changed? What can we do? Sometimes it's issues at home. EAP. We look at the holistic process. So when I ask for a speedy process, it's not just because I want to get it gone and be done. I want that employee to have some finality so we can move the organization forward, so that when those employees are out working, they're not spending time of, I wonder what's going to happen and how long it's going to take. It's, I'm going to have an answer in 2 weeks.
Or sitting home getting paid.
Pardon?
Or sitting home getting paid
Or getting-
while waiting for a decision to be rendered.
That's not a practice I really believe in. I don't want to lose that productivity. I want that employee to be at work. And again, let's get it done. So if that is a resolution, that I don't agree with. I think that is a practice that is very contrary to efficient operations of the organization.
And Chief, ever since you've stepped in, the morale, I mean, I can tell from the interaction of that department is just shot up with the changes that you've implemented. So
it is not my doing. It is absolutely the leadership of the management here in City Hall, our POA, and all the members of the department who are coming together and coming up with new ideas of how we can make the organization more successful. So
absolutely.
I take very little credit for any of the improvements that have been made.
Absolutely. Okay.
I'm sorry. Does anybody else have any more questions?
I mean, the thing that I've been sitting here listening, and it seems like from everything that you're saying, this happens very infrequently to begin with, and then with all of the programs that you've implemented and the processes that you've changed, it's even going to happen less frequently. So we're really talking about something that's going to come up maybe once every 3 years, looking at precedents. So I don't really understand the concern in morale being affected and productivity being lessened if this is just an isolated incident once every few years. I mean, what am I missing?
I don't think you're missing anything. It's just all I'm asking for is a process, whatever that process may be, that meets the needs of what I'm trying to do with the organization.
Yeah.
And I hear you, Chief.
And Commissioner Yakubian, I agree with you, and part of me also knowing sometimes the nature of things of this, when it comes to bonus removals and lack of performance, it comes up, and and the feel that I'm getting is the chief, having stepped into a position, has bonus positions there that currently that he has individuals there, and he wants to know that he has a process that he can go to if he feels other people may be best fit for those bonus positions. And that may be the case, that may not be the case, but the fact remains that the chief needs a expedited process. I know that having been part of this commission and trying to schedule everybody's calendars when it comes to hearings, it would take a little bit longer than having a single person hearing officer hearing the cases, and we do the final adoption of it. If you have questions on a hearing officer's report, we'll have the ability to send it back.
No, it's got to be one of us, is what my suggestion was. The hearing officer would be one of the commissioners, not an outside hearing officer.
Whatever the case, it'll just be a quicker process.
Anything else? Anything else?
No.
I will just say, if you do know, Chief, and if you're at liberty to reveal, are there currently uniform standards where an officer goes into a particular 5% increase pay position, detective bureau, if you will? Does that officer gets to go there by an order of the chief or a supervisor for a determinate period of time, after which, at will, he is to rotate out, or at will, he may remain for an additional period of time until a qualified person is brought up to fill that rank, so that that turnover does take place, so that everybody is equally experienced, but yet that officer who now is a detective gets.
The Glendale Parks and Open Space Foundation is pleased to announce the third annual Glendale City Golf Championship, which will be held July 2014.
Something in place that would further reduce the viability of such a claim of grievance, it would be perhaps useful.
Well, there currently is a transfer policy in place.
Okay.
That was put in place prior to my arrival. That policy is under review and discussion to change.
Okay.
And we also are looking at the natural rotation. We're not just looking at times, we're looking at going back and saying just the natural movement as retirements occur, promotions occur, lifestyle changes occur. You know, we're looking at what's the natural, we just want a healthy rotation within the organization. I want that for just general movement, for the development of this department and the development of its personnel.
Yeah, I mean, a detective who's in narcotics and has a newborn probably is not the best detective because he's going to get up in the middle of the night or have further distractions. I mean, those are all life-changing.
Hi, this is Brian Byrne, Mr. Rock and Roll. Join me for Glendale's 21st Annual Cruise Night, Southern California's most...
Who's shooting in the door?
I thought you had talked to somebody.
No, I don't. I just thought of it, actually.
I have one question for the chief and recommendation. Do you have a problem with allowing the problem with the employee deciding if he wants to come to the civil service or go to the recommended?
I believe we should have a standard unified process, whatever that process is going to end up
So
being.
not give the employee the choice to go to civil service or to go to Mrs. Beers?
I'd rather have one standardized process so that all the decisions are made in the same light, under the same process. That's just my opinion. Sure.
We are talking about one in every, what? I mean, we've sat here for 2 hours to go over this, that it only applies to, in how many years?
7 years.
In 7 years, we've seen what? Two. If that. I mean, so at least that's my recommendation, to at least give the employee the option.
As long as the employee is not denied or deprived the right to come to civil service, because I view this as a civil service right of an employee who is being transferred based on a disciplinary context.
The thing is that...
Then, go ahead.
The thing is that you can have kind of both worlds, because the civil service process is an appeals process, but internally you can have a review process, similar to, let's say, a CCW hearing where you have a concealed weapons hearing. You'll have a member of the union that will come sit in. You'll have a high-ranking internal individual that will sit in, and you'll have an independent person that will sit in and will do a comprised report for the chief's consideration. Once the chief makes a decision, then that employee has the opportunity to appeal that decision to the Civil Service Commission. And what that does, it gets rid of a lot of the hiccups that we come across sometimes with the investigations that we see, not particularly Glendale Police Department, but just in general. But the chief internally has a review process, brings in an independent person. Again, it could be somebody who's retired, it could be a commissioner, it could be a hearing officer, however the chief chooses. And then you have an internal person, high-ranking captain maybe, and you also have a union rep. And that creates a quorum. It's obvious to know which sides the two are going to vote, the union member and the high-ranking captain. Maybe not, right? But you get that independent person in there, and you get a view before the final decision is made. And then externally, you have the appeals process. So you have a review, and it satisfies, from my perspective, what the city attorney was trying to represent, in my view, as to having some type of an internal process where you have a review process internally, and once the final decision is made, then you go into the Scaly and civil service and so on. But that's just...
So we created another layer.
Right now, for a routine transfer, so an example would be traffic, riding a motorcycle, very specialized skill. We have some officers assigned to traffic who've been riding bikes for a long time. Recommendation was made based on the current transfer policy to consider transfer. But we don't have qualified people ready to step into that position. So it makes no interest for public safety for me to move a qualified officer out of that specialized traffic unit when traffic is such a critical area for us, and the officer is willing to consider and stay into that position. So that process is already occurring in the organization. We're looking at, okay, the policy says yes, but what is the best interest of the community and our ability to provide public safety? And that outweighs a policy policies are created for smooth process, the smooth process, but they can't hinder the operational effectiveness of the organization. And our process that we're talking about today, I'm just asking for that same attention. Do not have a process that doesn't allow me to run the organization in a manner that I see fit.
Why don't you, his recommendation, Commissioner Hatamia's recommendation for the chief,
I mean, from my experience, that's a case review process. It applies to all cases, including discipline, removals, demotions, where you have that review process internally so you have a better understanding of what the viewpoints are going to be. And then once you make a final decision, then as Garo recommended and as it's done from my experience in the county, you have a hearing officer, a single hearing officer that's scheduled to hear that matter. Once that matter is finalized, then it's presented to the commission for a final decision. But you have an internal and an external process, as it was brought up by city attorney, of wanting to have something similar to that. It creates another layer, but then the internal process, it's fast because you can get those people in one room in a couple of days, if not within a week. They do a full review. You get a full understanding from the different perspectives, the different viewpoints, and then once you make your final decision, then you move on to the civil service process if the employee chooses to appeal it. But sometimes when that case review is done,
it's resolved.
It gets resolved because the employee sees that, hey, there's a neutral person sitting there, there's a union guy sitting there, there's a high-ranking Glendale PD guy sitting there, and you know what? They came in favor of the chief.
Well,
and it
I
helps.
have to tell you this, is that there's this misconception that the chief is not a neutral party. And I have to tell you that, especially coming from the outside.
I love your honesty.
I mean, there is that, and you can talk to the POA because we meet regularly and discuss issues so that we have a common ground and we have understandings of each other's roles. But I can tell you this: I don't see myself as being biased towards management's recommendations, and in many times I've been accused of being overly protective of my employees because I truly believe
that is the pleasant rumor, Chief, that Sam Manukian is alluding to. That Chief, is the pleasant rumor, isn't it?
We're not saying that. It's just when you look at lawsuits in the eyes of the court, you get that. So I mean, we definitely appreciate and respect what you brought to the department.
Don't feel bad. Judges are sometimes looked at as not neutral parties, but they are neutral parties. And I have no doubt that you and even the former chief, he did his best, as I'm sure you'll do your best, to try and be really a neutral person when something comes before you, because when something comes before you, it's not just coming from IA, it's also coming from the perspective of the aggrieved party seeking redress by his or her chief. And as chief, you obviously are all of the rank and file's chief, and you have a different duty than an IA or a command staff member to really be objective and see if those under your command got it right. And I hope that you will do the right thing. I'm sure you will.
Thank you for reducing the number of IAs.
Yes, there's been none. Go ahead.
Putting this all together, I have a suggestion.
Sure.
If I could.
I want to hear from the GPOA before we make a decision, but go ahead.
Okay, well, my suggestion would be either before or after we hear from GPOA. What if we adopted the administrative appeal procedure as we see here with one change in it?
What is that procedure? Can you refer me? Exhibit 10, yeah.
With one change that where it says that the officer shall have an appeal to the Superior Court, he shall have an appeal to Civil Service Commission.
Second that motion.
That way, they can go through all of these steps
Where is that?
spelled out here, either with the city manager's office and the chief or whoever. And with the chief's new philosophy on discipline, I think that the process would end there. It would never have to be appealed to Civil Service because I think that he will work it out with the people. So that way we can have our cake and eat it too. They can have their process, but we just allow them at the end of the day, instead of going to Superior Court, they come back to Civil Service.
Show me the last portion that you're seeking. Where is it that you're seeking to modify?
just think the issue with that may be that now we're adding another layer. So we go to the admin appeal procedure. If the employee isn't happy with the outcome, then they can come to the commission for another full hearing and then go to the Superior Court. So I think that's actually would be adding time to the process as opposed to making it shorter.
Well, do you think they have a right to go to the civil? Do you think they have a right to go to Superior Court?
Yes.
You do. So if they have a right to go to Superior Court, how could you then say they don't have a right to come to civil service?
I didn't say they don't have a right.
Right, but that's what that would be. So I would think that what Commissioner Devine was suggesting, put in this memo that they come to the Civil Service Commission, because certainly by then your record is far more significant and the layers of review are far more significant. Otherwise, what you are going to be accused of doing is that you are banking on the fact that a poor old employee at the police department is not going to spend the money to seek judicial review, and therefore that's going to be the end of it. And then that's going to affect morale.
But are you suggesting it would be a de novo review before the commission, so they would have the admin appeal and then come here as if they never had that hearing and have a full another?
No, they should not have a full hearing. I agree with you.
Then I guess we need to work that out.
I think that's a very good point, Ms. Maurer, because I thought about it a half hour ago or so when the conversation was ongoing, that if they are afforded an opportunity, with, let's say in this case with Ms. Yasmin Beers, where there was witnesses or there's presentation made, I think at that point, subsequent to that, coming to this body ought not be a trial de novo type administrative hearing, but rather a truly appellate process where both parties make a presentation, present oral argument or briefs, and we decide if all was well or all wasn't well. That, I don't know if that would be appropriate under the law.
No, Chair Gazarian, I was going to comment on the recommendations for the appointing authority and the officer to come up with a procedure. That would be outside the purview of this commission. You really want to allow them the opportunity to determine an informal process as they see fit. It's something that the chief can do in working with the GPOA or otherwise. What's before the commission is this ability to appeal, the officer's right to appeal to the commission if there is a transfer combined with the loss of pay. So those are the things that you're considering. While your suggestions are great, and I'm sure the chief is making note of them, you really want to limit your discussion to the formal hearing process that an officer needs to be afforded once they're transferred and there's a loss of pay.
I painfully have to go back to my original position, and that is, Chief, with a pained heart, yes, the officer would have the right to Civil Service Commission review. The rules are clear. I mean, I don't know how anyone can see otherwise, Ms. Maurer.
And I'm not saying they don't have the right. I'm saying that we, with the GPOA, were trying to agree to a process that would preserve their rights but make it...
The GPOA cannot do that. The GPOA is not the right party to do that. And maybe the city attorney is the right party to do that, but the GPOA is not the right party to do that, because that, to me, requires amendment of the charter.
Maybe we could suggest some rules to modifications to how the hearing would be conducted in those scenarios that we could bring back for discussion, limiting time or setting, an outside time limit for how long it will take to conduct a hearing or something like that, just so that we can ensure everyone's on board with those rules.
And if I'm hearing, Chair, go ahead.
Sorry, if I need to address this.
Sure.
Very, very clearly. In our view, to implement this procedure does not need an amendment to the charter.
I've heard that.
Arguably, it needs an amendment to the rules, and I think that's the position was if the commission felt strongly about this, then that it's in the rules, then the recommendation would be to amend the rules. We see where that part of the discussion is going, but by virtue of the fact that the Civil Service Commission rules have been adopted to implement the provisions of the charter, do not mean that the charter requires that this be come before the Civil Service Commission. If it is required to come before the Civil Service Commission, it's because the rules require it. So legally, the charter is this is not required by the charter. We're here because
The law.
There's some ambiguity in the rules, and in addition, because the staff previously came to the commission and said, please take this particular responsibility on, and then we didn't come back to you. So I just wanted to make that clear. And then I do really have to echo Ms. Maurer's point about just if actually adding on the Civil Service Commission review to the existing policy. In most circumstances, would lengthen the process, not shorten it.
Well,
what do you think I'm sorry.
Let me just address that real quickly. What is the difference between the officer having the ability to appeal it to the Civil Service Commission after it goes through this process, or his appealing it to Superior Court?
Because, well, he'll still have the opportunity to do both, but at the time that the decision is final, the chief would have the opportunity to implement it. So if we have this process that it comes before you, it doesn't become final until you agree.
Well, it doesn't become final even with us because you could still appeal it to the Superior Court.
But it becomes final at the time that the final decision maker has it. It would be incumbent on anybody challenging it in court to go and seek a stay of the implementation of that particular order. Those stays are rarely granted. The employee would have to show extenuating circumstances. So that's a big difference because you're right. The court procedure obviously takes a very long time, probably at least a year.
Right.
But our position would be, in 99% of the cases, that once the decision is final, whether it be this hearing officer procedure that was currently implemented or the Civil Service Commission, once it's final, then the chief, the appointing authority is then authorized to actually implement that particular action.
What's the ambiguity in the rules that you spoke of?
Well, I think with respect specifically to performance-based transfers, I don't think in our view, the civil service rules there are to protect property interests that result and the loss of those property interests that result from discipline.
Thank you. Demotion, performance-based transfer, is a due process right that you have to afford, Mr. Garcia.
But our position is that a performance-based transfer, there are many performance-based transfers that are not disciplinary-based. They're not, as Chief Castro explained, they're not because the employee misbehaved or violated a rule. It's just the person that is in that particular position. The chief wants to put somebody in there that needs to put somebody in there that's better. The person that's performing it is not performing at the level that the chief needs. That's different than disciplinary-based transfer.
Performance-based transfers that also have a salary reduction.
Right.
Correct. And
so
like I said,
the disciplinary actions say that, Mr. Garcia, with all due respect. I mean, they say temporary or permanent reductions in classification or pay. I mean, that's what the definition is. So I don't know where the ambiguity is.
Because that section has to do with discipline. And again, our view is that it's they're part and parcel of each other. You have to have discipline, and you have to have either a suspension, a removal, a reduction in pay.
Mr. Garcia, that section defines discipline.
Exactly.
It has to do with discipline. It defines it as that.
But our view is looking at the totality of the rules and looking at, again, as you've stated, Mr. Chair, that those rules are there to implement the charter provision.
Right.
And the charter provision, respectfully, is there to protect the property interests of the employees who have a
agreed
for disciplinary reasons.
Mm-hmm.
So again, and I think we're supported by the law here. The reason that we have to provide these hearings in the first place is because of POBR, that particular section of the government code, not because it's required by the Constitution.
No, 3303 and 3304 of the government code.
We provide due process. Because it's required by the Constitution, we require these hearings for for removals, suspensions, or reductions in rank and grade. That's the only thing the charter requires these hearings to be, because it's required by the charter. This particular requirement to have a hearing, to have some due process, is a statutory right, and we don't believe that, at least in the context of performance-based transfers, that it is required to be before the civil.
But it's derived from due process rights by the Constitution.
But you did just, I mean, I'm trying to understand if you and I are saying the same thing. I mean, I think you're saying that it requires a rule amendment. Is that correct?
I think it's best to amend. What requires a rule
Mr. Cubian, before we go there, if I may, please, before we go to that line, Mr. Garcia, I'd like to talk about performance-based transfers a little bit, because...
Actually, with all respect, I mean,
hold on, guys.
We don't want to...
Hold on.
Because that takes the argument to the next level of talking about...
Hold on, I'm running the meeting. Hold on, please. All right, I will allow you. Go ahead.
Thank you. I don't want to go to the step of talking about any amendments before we clarify what you stated earlier, which is you may have transfers where it's performance-based, but it doesn't result in discipline. Is that correct? And hence, you're saying...
It's not a result of discipline. It's not for disciplinary reasons.
Okay, but let's say you have an employee, lacks performance, You're saying it's not discipline, so therefore the charter does not cover it, and the chief, at that point, even though it's a pay reduction, would be allowed, based on what you're saying, to transfer that individual. Is that correct?
Correct.
Okay. The department has a policy regarding performance of standards and performance of duty. Is that correct?
Yes.
Okay. So we're splitting hairs here, and we're walking a really fine line, because when you're talking about somebody who lacks performance and you want to transfer that person, but you're going to call it non-disciplinary,
it's disciplinary.
Then you're saying, I'm transferring you because I essentially don't like you in that position. I can't articulate why I'm going to transfer you clearly, because I can't say it's discipline based, but I can only say you're not performing to standards, and I'm going to get you out of here. See, those positions are given, those positions are given, and there's a pay increase. That person is put into that position, they have a probationary period, usually, typically, and then they fulfill it, and then they become permanent. Now, that person is in that position. The only way that person can be removed is if you have a performance issue. Now, you're going to...
Or a rotation.
Or a rotation, whatever the case.
Right.
To say that I'm going to remove an individual off of bonus pay, they're not performing to standards, but it's not disciplinary based, it doesn't really jive if you get it from our perspective, because we see it as one, and that's splitting hairs. And if you say the individual lacks performance, okay, then you're not performing up to standards. Unless that person is a probationary employee, then you're going to say, let's get him out of here, let's make sure we document everything and get him out of here. But it's not the case.
Yeah.
So it's not as clear-cut as you make it seem under the charter.
I think there are probably some examples that don't come to mind right now.
Okay.
And maybe the chief can help. But I do believe there is a difference, more than just hair splitting, substantively, between the department wanting to transfer someone for performance reasons, but wouldn't necessarily rise, that performance issue doesn't necessarily rise to the level of discipline. For example, under the civil service rules, there can be a discipline for performance, but it has to be essentially incompetence. That's what's in the rule. So I don't know if there are other bases for poor performance that, and Mr. Doyle can correct me if I'm wrong, that allow a department to discipline an employee for poor performance, other than when it rises to the level of not performing job duties or being incompetent. And that's different than the department saying the person in this position, this specialized position, is not performing at the level that I need for this particular unit to function how I need. There's a difference there, and we've talked.
I completely agree.
But you know, how's that different? You know, forgive me. You're very articulate, and I admire the way you are advocating for the position that you want to be adopted here. But how is that any different than a police officer who is duly employed, but here's someone that wants to be a police officer who would make a better police officer? Do we remove the police officer from his position and bring the outside person and make him a police officer? We do not. So we do not deprive him of the job. So this person who is in a position, the best case scenario you can advocate for me is to say someone is better qualified for that position, and I want to put that person there. But even when you do that, you're essentially, unless you're able to get around the punitive nature of moving the other person, that's one thing. That's why I suggested to the chief, is there a rotation concept to this where maybe you have more latitude because
there is a process, and the chief talked about it a little bit. But again, this is for those situations where the process is that person is not due to be transferred out until a particular time. So. Again, I think your example. I think with. I understand the point that you're making. I just think that from a perspective of what I just heard Chief Castro say, is that there's a need to make a decision, make it quickly,
Right.
and it's different and again, it's different from discipline. I mean, when you disciplining someone and you are removing them, suspending them. Reducing their rank, reducing their grade within their rank,
right.
For disciplinary reasons. It's above and beyond just poor poor performance, because even poor performance there has to be a process whereby you are giving that person the right to correct themselves, that sort of thing. But what the chief has explained is that sometimes he doesn't have the luxury of doing that, and sometimes he needs to make the decision and do so quickly.
Yeah, Mr. Garcia, I completely agree with you when it comes to specialized positions, bonus positions, and the need of the department when it comes to transfers and the removals. And hence, when you're talking about lack of performance of duty in a specialized position, and you look at the general guidelines and you look for specific or major or gross lack of performance in a specialized position, the performance is so specific, whether they're a training officer or assigned to a specialized unit, that it's, when you're trying to say that the person lacked performance of duty, it's easier to come over that threshold and say, look, these are the specialized assignments for this individual, and he lacked A and B, and hence he failed to perform the duty. There you have a policy violation. Versus when you have a general position and you want to go for a performance of duty charge. And that's why, for me personally, and I can speak on behalf of the commission, this is just me personally, when it comes to performance of duty in a specialized position, and you say this guy is not performing to standards, whatever it may be, he lacks morale, he's not doing the specialized function that is articulated for his bonus position, then that is a performance to duty issue. And whether it's a written reprimand or...
Sir, I would submit to you that that's why we're here.
Yeah, and when you have that...
That's the only reason we're here.
So then we agree that the charter does talk about performance of duty, then if that's the reason why we're here. Because if it is a performance of duty based issue, the civil service rules clearly discuss that. And I hope we can agree on that, because we are kind of splitting this hair of saying, well, the guy lacks performance, but the civil service rules don't.
Could I just add a little more to that? The charter requires that the commission and the council agree on rules, and it specifically states what areas of employment the commission needs to adopt rules on. The specific rule itself is captured in the civil service rules, and what is being proposed here is a process that would allow that administrative appeal process to be go through the city manager's office versus so that is within the commission's purview to permit that, and so it isn't something that would require a charter amendment.
It's within the commission's purview to permit that. Yes, I understand that.
But it would require a rule amendment, which is what I've been trying to find out this whole time. No one wants to answer my question.
Yes, it should. If we're going to go forward with this as what we were recommending, it's best to put it in a rule amendment. I agree with that. Whether it requires it, we can have reasonable debates about it, but I think it's best to actually...
I just think that it does require... May I?
Yes, because he was next. Go ahead. Go ahead. It's okay. Go ahead.
I was sort of interrupted before.
That's okay. Please go ahead.
The only reason I do think that is because of the very definition of disciplinary action. Whenever there is any reduction in pay, that's automatically, whether or not the intent was to discipline or not, it's defined as disciplinary action. So, I mean,
like I said, I certainly
understand.
I understand the point.
Thank you.
Thank you.
Could I say something?
After Commissioner Devine.
Okay, we've gone over this. Sorry. 40 times already since 6 o'clock, and we keep rehashing the same thing. And what I think the real bottom line is this. 5 people on this side right now, 3.
I've lost he's in the restroom. I've lost Commissioner Manukian.
5 of us are saying that we don't want to see the Civil Service Commission excluded from the process during these appeals. And people on that side are saying, and for very good reasons. I think the chief brought up some excellent reasons. I think you're bringing up some excellent reasons. You're saying that you'd like to adopt this procedure that does exclude the commission. And I don't think you're going to get 3 votes to go along with that type of scenario. So I would go back to my original suggestion a few minutes ago that we amend this procedure to include the Civil Service Commission as part of the review process, and ask whether it's your staff, or Matt's staff to come up with a procedure that will allow that to happen. And because we can sit here and discuss performance and disciplinary and thing, and we'll never come to a decision. What we do have to decide on is which way are we going to go. And I think, again, hearing from the five of us, you know that we're not going to approve a process in which the commission is excluded. I think that the chief brings up a good point. I think Commissioner Gazarian brought up an excellent point that to address the chief's concern, we have one hearing officer from the commission hear it, which I think would be the same as having someone from management hear it as a hearing officer and resolve it that way. But I think we ought to move forward at this point and say that we're going to amend these rules or come up with another process that will incorporate the time-saving element the chief wants and accomplish what the commission wants in being involved in the process.
In the absence of that, in the absence of the city being inclined to accept a recommendation by Commissioner Devine, which I concur with, I would ask that you take a look at administrative appeal procedure, and in the first paragraph, when it says it shall supplement, though not replace, the existing disciplinary appeal process established pursuant to civil service rules and regulations, you acknowledge the fact that the disciplinary hearing process established in the City of Glendale Rules of Civil Service Commission specifically provide in Rule 10, subsection 1, subsection B, disciplinary actions include temporary or permanent reductions in classification or pay. So this process, excluding this body from being a body that an aggrieved party can come to, is contrary to the current rules. And absent any amendment, I would strongly urge you to no longer rely on it or implement it or practice it as a procedure and a process in the city as it relates to the officers of the police department. That would be my strong recommendation.
May I address that, Mr. Chair?
Yes, of course.
First, as I stated from the outset, we took the view that because we had come to you and said the commission should take these on, that absent an agreement by the commission through this process we're going through now and a rule amendment, that we wouldn't implement that administrative policy until we've come to some resolution of
But
it.
I thought it was implemented in 2011.
It had been.
Right.
I'm just saying today,
Right.
if we had something come in the door
Okay.
today,
Okay.
we wouldn't be following it because we knew we had come to you and previously in 2008 and said these are going to be coming to you. And as we've said, for some reason we were not really clear. We forgot to come back.
But had you not come to us, Mr. Garcia, it seems like the rules are there, Rule 10, subsection 1B, that would have compelled you or the other side to come to us anyway. It's right there in black and white. So it's not like you came to us in 2008 and gave us an added authority that we are now saying don't take it away from us. It was there.
Again, our interpretation had been that the rule didn't cover it, and the commissioners that were sitting, I think Mr. Devine was on that commission at that time, and I think some of the commissioners voiced some of the same concerns that you've raised today. But I think at the end of the day, they say, okay, they nevertheless took a motion to say, yes, bring those to us. And then the other thing I would just add that we're willing to, we're obviously willing to come and say, let's do a rule amendment to allow this administrative procedure. I just don't know, listening to you today, where the commission is on that. I've heard, for example, Commissioner Hatamian say he does see a distinction between with a performance-based transfer related to a specialized assignment versus other performance-based transfers and disciplinary actions. Maybe I misheard you. And then I think Commissioner Yakubian has strongly advocated that it needs a rule change one way or the other, but we haven't gotten clear direction.
I only have an issue with the reduction in pay. When there's a reduction in pay, I believe it becomes an issue that is charter-driven, regardless of the fact that you and I disagree on what is covered under the charter. I believe that becomes a charter issue. I think it's the reduction in pay that concerns me. I think one way to go around it is to make these promotions or elite unit assignments not be time-driven or even permanent in nature. You're there now, you're going to get 5% for as long as we keep you there, and we may move you at will. Then that's one way of doing it. I don't know. I mean, I'm not a labor specialist. I don't know how that works, but I'm not going to tell the department how to run it.
I would say this, then, assuming that the commission is not willing to entertain a motion, not and a motion wouldn't be today, but to provide direction to entertain a motion to change the rule, then we are asking that you give us direction to come back with proposed amendments to the rule that would kind of incorporate some of the topics you discussed, such as having one civil service hearing commissioner hear it with a drop-dead deadline for that commissioner to hear the item, and then put that into the rule so that both the commission and the city council can review that rule and weigh into it, and then we can bring that matter forward.
That I can make yet another recommendation for you to contemplate with the city management and et cetera, and that is perhaps an amendment that provides for one hearing officer assigned by the commission to hear it within a 30-day period, present the findings to the commission, and unless the commission issues a decision to the contrary of the decision reached by the hearing officer at the administrative level, and for example's sake, I'm going to say Ms. Beers, her decision becomes final. You see what I'm saying? So in other words,
I actually prefer Mr.
So that becomes Ms. Beers has to have her hearing. She ought to conduct her hearing. It's not. I would want that to continue to be in place, because that would, in my opinion, reduce the likelihood of matters coming to the commission, but it would at the same time not take away the right of an officer to seek review by the Civil Service Commission. For that officer who seeks review by the Civil Service Commission, the Civil Service Commission, by rule amendment, will assign one officer, may assign more than one, but one is sufficient to review the findings made by the assistant city manager or whoever the designated party was at the lower level. And then unless the commission as a whole issues a contrary opinion, the opinion of the hearing officer, in this case Ms. Beers, will be final. That would be my recommendation to my colleagues and to you to consider.
Well, I would.
Yeah.
I just gave the 30 days. Yes. I just did that.
Again,
I don't know. Maybe that's reasonable. Maybe that's not reasonable.
What I would suggest at this point is, I think we're going to have a lot of suggestions. To come back on specifics, we'll take your suggestions now and then bring those back. I mean, we've said a couple of times, we think that having the city manager's office and commission involved
Duplicative.
Is not duplicative, but actually has the potential to lengthen the process. And we are concerned about the timeline too. I mean, again, I think we're thinking something in the range of 14 days. But rather than have this debate, given the amount of discussion we've had so far, I think if you could give us direction to bring back some of the options in line with what you've already discussed, we can do that.
I would actually like to make a motion similar to what Mr. Garcia suggested, for Mr. Garcia to go back and talk to whoever that you need to talk to come up with some system that is workable for you, so that we can review that and then vote and decide accordingly.
Okay, before I entertain or I allow your motion to be seconded, I would ask Mr. Garcia if you would yield the podium. I would briefly like to hear from Sergeant Jason Ross with respect to any, if at all, perspective as to this issue.
Chairman Gazarian, Commissioners.
Hello.
Not sure where to start. Been here a long time. I think that we've got a very complicated issue here. I think that the administrative appeal process that was brought forth to be discussed today was at one point a product of negotiations subject to meet and confer in the Myers-Millis-Brown Act. I would have concerns if that administrative appeal process was to just simply be adopted by the civil service, considering at one point it was in the negotiation room. And I would just ask that if these suggestions are arranged in some form of proposal to amending the civil service rules, that we have an opportunity to consult with our attorney and make sure that we don't stumble into anything where we've somehow given up a right to negotiate this issue. Aside from that, I think that we have spent a great deal of time talking about a very rare occurrence. I'll keep it short.
Yeah. I would like to see the civil service rules be deemed to be the driving force and the directive language that sends such a matter before this body, and wait and see if such a person will come seeking redress. Because I have been here 2.5 years. I've never seen such a person come here. Not for this particular issue, at least, not yet. Thank you for your input. I think we will table that. I think your motion is a motion to table it.
Mr. Chair, and let me assure Sergeant Ross, any change, any modification, anything relating to this policy or whatever is brought forth before the commission would be subject to meet and confer, and I want to assure Jason that we would certainly address that with him.
Very well.
Chair Kazarian.
Yes.
We will not need the motion. What we're doing is
we're going to table it.
Well, we're not tabling it, but we're hearing direction. We're receiving direction from the commission to bring back a few alternatives so that you may consider it at a later time.
I think the record, as lengthy as it has been, and I'm sure it's being recorded, will provide an opportunity for the interested parties to review, hear, and see my ugly face and others' pretty faces, and probably glean quite a few recommendations from the commission or concerns by the commission.
So if there's no other new ideas that you'd like to propose, we've been taking notes of your comments, and we can bring that back at a later time.
Not at this moment. Thank you. Thank you very much for all those who participated. I would ask that we call the next item, please.
Reports past due employee performance evaluations.
Thank you, Mr. Doyle. I've looked at the matter, so I know there aren't any third notices.
Yes, there are.
Third notices? I didn't see any third notices.
Clerk.
Really? I missed it.
Mr. Chair, members of the commission,
yes.
The city clerk did in fact have two late evaluations. He has, however, today turned in those evaluations to my office and asked if he could not appear today, and I granted him that luxury. So he did get the job done, and they're in, and we're satisfied. So
okay.
And Artie's not here, so
very well. Let's move on to the next item, please.
Civil Service Commission staff comments.
No comments.
Mr. Chair.
Yes.
Just one comment,
You have a comment.
and I'd be remiss if I didn't recognize an employee of HR, of Human Resources, who's no longer with us, Narne Kasparian. And we wanted to have the opportunity for you to say goodbye to her. She's resigned as of the end of May. But we had a couple meetings canceled. But Narne was a Human Resources assistant, a very, very outstanding staff member. And she has decided to be a stay-at-home mom. She's had a child in the last year, and a tough decision. She had a great future with us and did great work, and we were really happy with her. But I think the pull of being a stay-at-home mom, I think was an overriding decision. But I do want to say, she was an outstanding employee, and we're certainly sorry to see them go. And I wanted to make sure the commission was aware of that. So
we thank her service, and I could say that the role of a mother is the most unrecognized, but the most important career any human being can have. And what do you know? It's limited to women. So my hat's off to women for being mothers and doing a great job raising our future generations. Thank you.
Thank you.
Anybody else? Anything else? Okay, thank you. Next item, please.
Adjournment.
So Oscar, there is nothing. So there was item 14 here. There is no such thing, right? A closed session.
There is none.
There is not. Okay, adjournment. We are adjourned. Thank you.
What were you looking